Hi, everyone. I'm Judy the YouTube Lawyer. Today's episode brings us a special guest, attorney Cyril Yu, who is a senior attorney with the Orange County District Attorney's Office in California. So let's bring Mr. Yu to the screen. Hi, Cyril.
Hi, Judy. Good to see you.
Yeah, great to see you. So to those listeners out there, I have known Cyril since we were both in college together at UC Berkeley, and we also started at UC, or now it's called Hastings College of Law, right?
Well, they changed it to University of California College of Law, San Francisco. So
Oh,
that's a
that's right.
mouthful. Yeah.
Okay. So they changed their name. So okay, interesting. So it's great to have Cyril Yu back on the show. This time we're going to focus a little bit more on the Bryan Kohberger case regarding the murder of the 4 University of Idaho students, as well as just in general how the prosecutors work behind the scenes and how they build up cases. So feel free to throw in your questions in the chat box if you guys have any. So Cyril, could you first just give us a little rundown of your background and how you wound up going to law school?
So like you mentioned before, the two of us went to UC Berkeley together. I majored in political science, had an interest in law from, started that interest back in high school and knew I was going to go to law school. Ended up going to, at the time, UC Hastings College of the Law, and volunteered at DA's offices while I was in law school. Applied to a couple offices after law school, but didn't have any luck. And eventually, after 4 years in civil, landed a job with the Orange County District Attorney's Office in 2002. And so I've been there 20 some odd years now,
Wow.
and kind of working my way through the various aspects of the office. I am currently in our post-conviction unit, focused on a piece of legislation that the California legislature enacted back in 2019 that affects murder convictions and people convicted of attempted murder. They expanded that portion of it last year. And so, yeah, that's what I've been working on for the past year plus.
Mm-hmm. Yeah, when you first started working at the DA's office, what kind of cases did you handle?
Well, we all start off kind of the same. We're working in misdemeanors. That's usually the first couple of years of our experience is working in misdemeanors. We're also getting some felony experience, but mainly in the before trial, pre-preliminary hearing stage, all the way up to preliminary hearing. And then as you work through, we do a felony trial assignment. After that, I was assigned to what we call our family protection unit, which handles domestic violence cases. Also physical child abuse as opposed to sexual child abuse. Those cases also fall into there. So anything in that arena is what we handle, including elder abuse. And then after that, I spent 10 years in our gang unit, handling all kinds of gang prosecutions all over the county, from vandalism all the way up to murder, and everything in between. So.
Mm-hmm. Yeah, and you were telling me that you have handled a bunch of different murder cases, correct?
Yeah, I've handled a couple murder trials, case I took to trial, as well as, prepared and worked cases at all stages, whether it's filing or pre-trials in the middle of litigation, preliminary hearings, things like that. So yeah, have a fair amount of experience dealing with murder charges and murder trials in California as well.
Mm-hmm. Well, and how much publicity did those cases get? Because it does seem like this Idaho student murder case has gotten so much national publicity all over the place.
It's not common for gang homicide. Mostly what I was working on are homicides involving gang members. And so most of the gang homicides don't result in any type of headline capturing, stories and that type of stuff, unless it's a really, unusual situation, a 6-year-old getting, caught and killed in crossfire, something like that. But none of my cases, although they would be written up in the local press, are not the types of cases that would typically garner, headlines statewide or even nationally.
Mm-hmm. Yeah. And can you guess why do you think this case has gotten so much publicity? You think it's because it had to do with, multiple people being killed all at once, or?
Obviously, anytime you have a case involving multiple people getting killed, that tends to, get into the headlines more. Your one-offs where you have, one person getting killed typically doesn't. This is obviously a unique set of circumstances involving 4 college students. So I think there's all kinds of aspects of it that, you're talking about something that doesn't normally happen, in I would imagine in Idaho and Washington State, there probably hasn't been in anything of this nature. And just, people get fascinated for all kinds of different reasons. And sometimes these stories, catch the attention of the country, and sometimes they don't.
Mm-hmm. Yeah. And I think also the fact that the main suspect at this point, of course, he's presumed innocent until proven guilty, Bryan Kohberger, seems to be a pretty high functioning, very intelligent, educated person, right?
Sure.
So he kind of flew under the radar. People thought he might have been a little weird or didn't know how to interact with people. But, there are plenty of people who are socially awkward that don't just go out on a killing rampage, right? So
Sure.
kind of his big surprise that somebody like him would somehow be able to, basically slaughter 4 young, healthy people. So
Yeah, it's hard to know what an individual is capable of, and obviously every homicide and murder is very different, and you have to look at the facts of the case, the facts of the individual, and quite frankly, in a lot of the cases, as prosecutors that we deal with, we don't ultimately find out what is the reason or motivation behind, a particular killing. Those things can go unsolved. That aspect of it may go unsolved. There may be aspects of the crime, and certainly in looking at some of the affidavit, for example, for the arrest warrant in this particular case, you get some information about what the facts and circumstances are, but there's still a lot of questions that are not specifically answered by those documents, and that ultimately may not be come to light until we get to a trial. And even then, the defendant may choose not to testify in that particular trial. You may not even get an opportunity to hear what his particular approach is, or you may hear information that comes depending on how the defense goes about putting together the defense. That'll give you some insight into it. But whenever I talk to jurors, I always tell them that there are certain things that you may never get an answer to the question for, but ultimately it doesn't really matter if you get all of your questions answered. But what matters is the most important questions, the questions that end up pointing to guilt or pointing to a not guilty verdict. Those are the questions that matter in a particular case. So like I said, some things you'll never find out. We may not necessarily know the answer to, but it doesn't necessarily change the fact that the prosecutor is able to put on their case.
Mm-hmm. Yeah. And in reading over his arrest affidavit, was there anything of note that it kind of jumped out to you?
I would say that this is very much typical of the type of police work that you see in any type of homicide investigation. You end up with a witness who sees part of what took place, didn't really have, obviously, at least from the account that's contained within the affidavit, a full understanding of everything, didn't see the actual murders happen, but was in the residence when it took place. So you get a witness who provides a piece of information. You end up with a piece of evidence that's left behind that ultimately leads to DNA evidence. You have law enforcement doing something that a lot of law enforcement agencies do around the country when you're trying to obtain DNA evidence, basically dumping people's trash and collecting something to get a sample and to get a hit off of that. Using cell tower data to use cell phones to corroborate where someone may have been before, during a particular crime, and though there wasn't any specific cell tower activity during the time period of the murders, they were able to put together a lot of that information that corroborates him driving into that area, him being in possession of that car before and after the crime, and even visiting that particular area earlier that particular day. So again, relying very heavily on cell phone technology, and then surveillance camera. I mean, the reality of our society is we have surveillance cameras everywhere, and the ability to go and collect that surveillance camera footage to kind of corroborate, okay, this is the same car that we're seeing, matching what our cell phone data is matching. And so a lot of what you see that's laid out in this affidavit, it's a lot of what the technology that we have available these days to put together cases, to be able to solve these things. And it really kind of helps you understand how the prosecutor or how law enforcement is going about putting together their case. Obviously, this type of work took a significant amount of time for them to get that work done. It isn't something that happens in a week, but you can tell from the timeline that they're working off of. They work very diligently to put this case together in a very short amount of time to get the arrest warrant together and to get them extradited to Idaho. So I think it's a stellar example of what law enforcement is capable of doing with technology and resources, as well as, the types of stuff we oftentimes will see in a regular case, which is, interviewing a witness, getting statements, and kind of putting all that stuff together.
Mm-hmm. Yeah, reading up for the arrest affidavit, I was kind of surprised that his vehicle was spotted so many times thanks to surveillance cameras. It's like everywhere.
Right. Well, once you know kind of where the vehicle is moving, and you can use cell tower stuff, and you can kind of corroborate some of that stuff. That stuff, unfortunately, you have to work pretty quickly, because most businesses with the surveillance camera, that footage isn't necessarily stuff that they're going to keep around for an extended period of time. It's not uncommon for businesses, depending on the nature of their system, to overwrite that surveillance footage within a week or 2 weeks of it. And also, those cameras aren't really designed to capture what's happening on the street for a car driving by. It's really focused oftentimes on the business itself, a parking lot, for example. And so you oftentimes kind of get lucky. You see a little glimpse of a white vehicle matching the description, flying by. But those little pieces, when you can put them all together, help create the image and the overall puzzle that you're trying to put together, and helps people, especially jurors, when you finally get to see the case, how that evidence kind of comes together. Because ultimately, this is a very strong circumstantial evidence case. DNA evidence, I think, is pretty powerful here in this particular instance. But you have a lot of different pieces that kind of come together. And like I was mentioning before, it's not clear from just reviewing the affidavit what could be the motive behind this particular killing or set of killings. And there's a lot of things that leave people up to start speculating. But as law enforcement, I think one of the things that's important is you put together a strong case. And as prosecutors, we don't try our cases in the press. There's no strategic advantage for us to do that. And so, we're keeping our investigation tight. And you can kind of see this in how this work is being done, and even in kind of how the court's even managing this overall. It's obviously, a case with a lot of public attention and scrutiny, but at the same time, the court's doing a very good job. And I think the prosecutor's office is doing a very good job of kind of, keeping that information tight, and trying, not to just try their case in the press, because, like I said, it doesn't necessarily help us to do that. You ultimately want to be able to put on a case and not prejudice your case along the way by something that somebody may have said along the way. Obviously, we can't control everybody. So if witnesses want to go out and talk, there's really no way of saying you can't do that. But that's just kind of how the nature of these things go.
Mm-hmm. Yeah. So in other words, the ADAs aren't going on the internet or Reddit or TikTok, searching for information.
I would, there may be investigators that do that. I mean, ultimately, the way this works is you have an investigative team with your law enforcement agency that is working up the case, that is then presenting it to the prosecutor's office. And a lot of prosecutors' office, my office is no different. We have our own team of investigators. These are typically people that are former law enforcement, that have worked in law enforcement for many, many years. And so they have an investigative background as well. So they're working hand in hand with the prosecutors as well as the investigating agency to marshal whatever evidence needs to be marshaled. If the DA needs certain work that needs to be done, they're going and doing that additional work, whether it's identifying additional witnesses or interviewing additional witnesses, and making sure that we're continuing to put the case together, so that by the time we get to whether it's a preliminary hearing or a trial, we have all the information we possibly can have in a particular case to be able to move forward.
Mm-hmm. Yeah. And I definitely like you to talk more about the whole process later, but we do have a bunch of questions that have already come in through the chat box. Let's jump around here a little bit. Thank you guys for being out here, and hopefully we'll be able to touch on everybody's questions. You had mentioned the DNA, ultra testosterone, asked how did he leave a sheath with DNA? That's what I'm not sure. Like, did he get cuts himself and then bleed onto the sheath? I'm not sure.
No, if every human being is constantly shedding DNA. Some people do more DNA shedding than others, but you can touch anything and you can leave DNA on it. I can touch this pen and I'm leaving my DNA on it. Now, some surfaces are better at, collecting, DNA than others, but there may be, amounts of DNA on this particular pen that I have now touched, that if somebody comes, with a swab and they swab it and they collect basically an evidentiary sample, they can then take it to the crime lab and go through their process and process it for DNA to see if there is DNA that's on there. So whether it's a knife, whether it's a sheath, for example, for a knife, your manipulation of that particular object, and people think, oh, if I put on gloves, it's not going to have, well, what were you doing before you put on the gloves, right? So anytime you're having contact with it, you are potentially leaving DNA on it, and can be skin to object transfer. It doesn't necessarily have to be saliva. It doesn't have to be blood. Those things are obviously very, very rich in our DNA, but you can certainly leave it that way. And then kind of the flip side of it, right? So we're not actually getting a sample from him directly, because if you look at the affidavit, the way that they did it to try and identify him was to collect garbage, right? So you're using the family residence, a limited number of people, putting garbage out, taking that, finding objects that are likely to have an individual's DNA. So for example, you might be looking for a used coffee cup, something that may have been used either as an article of clothing, something that would be rich in DNA, right? So the random piece of paper probably doesn't have a whole lot on it, but if you look for those items that may have it, what you're doing is you're trying to see, hey, can we identify a profile here? And then see if we can match up those profiles. And what for DNA analysis we do is that there are a certain number of markers that you're looking for and creating your standard DNA profile. And so when you have those markers and they match up, then you're able to give the mathematical analysis. They're using a percentage to eliminate. In California, or at least in how our crime lab works, it's 1 in 1 trillion people would have the same DNA profile. And so you're not saying it's a match, but what you're saying is the likelihood of this particular profile showing up in the population is 1 in 1 trillion, for example. So the likelihood of another person, it's like when you do the math, like what are the chances of another unrelated person being the one who leaves this? Because the one thing that is talked about in this is somebody other than his dad, his biological dad. Because obviously when you're talking about DNA and how we know mom and dad gives DNA to each individual person, you could obviously have a father as well as a son having very, very similar DNA profiles because of the fact that they're coming down from the same individual. So that's why, at least when it relates to family, you do have that exclusion just to make sure you've got that base covered. But when it's unrelated individuals, the chances of you seeing that same profile in the population is very, very small. And that's why they can provide that level of confidence. Now, obviously, from a defense standpoint, you're looking at it and trying to examine, are there other circumstances where this particular object could have ended up in this location? So for example, could you, and again, I know nothing about the police reports, haven't read anything, but hypothetically speaking, the defense may be looking into, was there somebody that may have broken into his residence, or maybe he had sold it at a yard sale or something like that, and somebody else purchases, has it, and then is the one who ends up using it, right? So there's other ways that the defense is going to look at it and say, well, this is a powerful piece of evidence. What is our way around it? What is our explanation as to how this object may have ended up in this particular residence? So that's the type of stuff that they're looking at, because they may not have a way of attacking the DNA evidence, assuming the DNA work is done correctly. But if you're a good defense attorney, you're also going to look at, did they follow protocol? What are we looking at? And that type of stuff in trying to attack some of the DNA evidence. But a lot of different ways of approaching some of these questions.
Yeah, that's right. Yeah, in the Dateline special that I was just watching, they said something about how there had been a party recently at that house with well over 100 people coming in and out of the house. They had lots of parties and people just showing up. So, who knows how anybody's DNA got in that house.
Well, obviously it's DNA very specific to an item. And the question is, how did that item get in that particular residence? And one of the things that we do get that the media may be trying to do is they're trying to get their own information, trying to fill in as many blanks as they can so that they can put together a story and add more to the story that's out there. But ultimately, it depends on the ability of, either the prosecution or the defense to marshal those witnesses and bring them into court. What are those witnesses actually saying? It's one thing to say it to the media. It's a different thing when you're saying it under oath. Is it consistent? And the level of detail that's oftentimes asked in those interviews is very, very important, because you're finding out, actually, that party didn't have that many people, or it was only confined to this particular portion of the house. Nobody went into one of the bedrooms, for example. there's a lot of things that law enforcement, or even from the defense standpoint, they're taking those things that the media may be, turning up, but they're taking a deep dive into it to see if there's anything there worth exploring. And it makes sense for both sides to do that work, because from the prosecutor standpoint, we want to make sure there aren't, gaps or holes or problems in what we're putting together. Because ultimately, if there is exculpatory evidence, we have an obligation to turn that over to the defense. And so we're ultimately in a quest for the truth, and to make sure that the story is what we understand to be based on the evidence which we're compiling.
Okay. This is another question. Thank you, Barry. I found it strange Bryan Kohberger's attorney in Pennsylvania used exonerated and not innocent. Is there a real difference in meaning in the law world? Exonerated suggests no blame or fault.
In the criminal realm, we only really talk about somebody being guilty or not guilty. So we don't really use the term exonerated. We don't usually use the term innocent. What you oftentimes may see after the fact is that there are procedures that take place where in California, for example, we have a motion which is called a factual innocence motion. But it's typically a situation where the prosecution has ultimately decided not to prosecute, either because we dismissed the case or chose not to file in the first place. And they may be looking at a situation where they're trying to either expunge their record entirely and remove it from even, as an arrest, but they have to come to court and basically prove that they were actually innocent. And that's a rare situation that's serving a very specific procedural, there's a very specific, criminal procedure that's happening in court. But most of the time, it's the way it's set up in the entire, country is the burden's on the people to prove someone guilty. So if a jury finds a defendant not guilty, they're not saying they're exonerated or they're innocent. They're just simply saying there wasn't enough evidence to prove the defendant guilty beyond a reasonable doubt. And that's ultimately what matters. But how that's characterized, defense attorneys are going to come in and say, hey, my guy's innocent. The evidence is going to exonerate my client. That's verbiage, but ultimately when a jury renders a verdict, it's not guilty or guilty.
Yeah, thanks for explaining that nuance there. Yeah. Okay, this is an easy question. Do you ever carry a badge like a cop does? Like you flash it when you're getting pulled over for speeding or something?
Well, you can't do that. At least for us, it's definitely frowned upon because you're not supposed to misuse your authority in that way. We very rarely carry our badges. We are issued a badge. A lot of prosecutors' offices do issue badges to their prosecutors. And I actually have one, but I don't actually use it. There isn't really any instances where that comes up where you do need it. The one place that it's oftentimes helpful is if you're going to visit a crime scene to have identification to indicate that you're law enforcement. But most of the time, especially if you're going to a homicide crime scene, your detectives know you're coming. And so it's not like, hey, somebody doesn't know I'm showing up. I'm just showing up at some random homicide scene. That's not normally how that happens. And so very rarely do we need to do that to carry a badge or a shield like that.
Thank you, Tony. This is the general question I wanted to ask you, which is, does law enforcement ever consult with you before or during investigation for advice on how to build a solid case?
They do. There is a working relationship between law enforcement and a prosecutor's office. There's obviously instances where you have to be careful of that because we have obligations that law enforcement may not necessarily understand. And if law enforcement does something that's improper, it's important that the prosecutor have enough independence from law enforcement to go a different direction or where necessary to put a microscope on an investigating agency who has perhaps done something improper. And in those instances, it's important to make sure that there is that distance between the two to maintain the independence, which is very, very important. But as you're working any particular case, you're going to have homicide detectives that are keeping you up to speed on things because they're going to want to let you know, hey, we're investigating this particular homicide. Do you want to come down and visit the scene? So, going back to the affidavit in this particular case, the affidavit talks about the fact of the detective showing up at a particular time. Well, once the scene is secure, once everything's, law enforcement's collecting the evidence they want, oftentimes prosecutors will want to visit a murder scene because it allows them to get a good flavor and a feel for where everything is. Those little things that help you down the road, whether it's 3-6 months down the road or a year later when you're putting on the case, to remember, okay, I know exactly where things are. Because it's those little details that you may not necessarily remember at the time that later may become important in a particular case. And there's that kind of benefit from going onto a scene and seeing that type of stuff, but you're coordinating with law enforcement to do that. As they're asking for warrants, you're getting an opportunity to review stuff, and you may give suggestions. Hey, have we considered doing that? Have we considered doing that? And so you're giving suggestions based on your own experience, and you're working with detectives or homicide detectives, and it varies in terms of the level of experience. Smaller agencies may not have as much experience. Big city agencies that have homicides constantly, you may have, homicide detectives that have done hundreds of homicide investigations. And so you may be able to provide them with suggestions and tips as to how to go about doing an investigation or focus on certain things. And it also allows you to start framing in your mind, how am I going to put this case together? What am I really looking at? What's the strongest evidence I have in a particular case? And so there is a lot of collaboration that kind of happens as the investigation is progressing. And like I mentioned before, as the case is, after it's even been filed, there may be situations where you're asking for additional investigation to take place. In some instances, you're going back to the original agency and having them do that work, or you're asking your own investigator that's in the DA's office to do that work. Kind of up to you, depending on what work you're getting done or who do you think is more capable of doing it. So the one example I'll quickly point out is we have an individual who's an investigator who is kind of the guru as it relates to cell towers and cell tower analysis and that type of stuff, and how he puts together the presentations and does the analysis of records and things like that, and what he thinks about. And he used to work for a law enforcement agency and then got hired by the DA's office. And so while there are oftentimes analysts at some of the other agencies that you could say, hey, could you put together that information or do the analysis? I oftentimes would rather go to him just because he knows it better, can turn around faster. And he and I think about things the same way. So it's like, hey, did you think about that? He's like, oh, I already thought about that. Here's what you're looking for. Or I've already looked at those records and here it is. And so, you really kind of rely on, who your experts are, who the people that have that training that can help you get that information together. And so that's where you kind of balance, am I going to the agency or am I going to somebody in-house?
Mm-hmm. I see. So in this Kohberger case, you would expect the district attorney's office to have already, been working a bit with the police?
Yeah, I would imagine so. Yeah, that they would have certainly been involved in some of the conversations around the warrants and what they were, and again, it really varies from state to state how different agencies do things. I will tell you that as it relates to Orange County, all of our warrants, if it's a warrant for a homicide, I'm reviewing that to make sure we're not missing anything before it gets passed to a judge for a judge to ultimately sign off on. And there's almost that built-in expectation from the court that has been reviewed by a district attorney before it's presented to them for signature. And there's obviously a reason why you want to make sure as a prosecutor that you do some of that. And one of the major reasons is that you want to ensure that your warrant has all of the information that's needed in it to support the issuance of that warrant. So you may have a judge that does a sloppy job, doesn't review it, and then signs a warrant, and it never sees a prosecutor. Well, down the road, if a defense attorney attacks that warrant and says, hey, this warrant should not have been issued, and a reviewing court says, you're right, that warrant shouldn't have been issued, all of this evidence is now out, that's on me, that's on my case, right? So I have to make sure that they're providing sufficient probable cause. And if there's something that I'm aware of that should be included in the warrant, I need to tell them, hey, you're missing this, please be sure to include it. Or I may ask the questions that will lead them to providing the information, because they may know it and I may not know the case well enough. I'm like, well, do you have any information about this? Do you have any information? Did you do a records check on this? Oh, yes, we did. Or no, we didn't. Why don't we do that? And then add that information in. That would be helpful to establishing probable cause when you're asking for X, Y, and Z. So again, there's good reasons as a prosecutor to want to make sure you're protecting your case, because you're making sure that all the I's are dotted and all the T's are crossed, because you don't want to have problems down the road where something gets thrown out because someone didn't do their job right.
Exactly. So nobody can be sloppy at any stage of the game. Yeah. Why are prosecutors guarded about making comments about a case beyond the complaint or indictment? Why not just lay all the cards on the table publicly at the outset?
Because we're not trying the case to the press, and we're not trying the case to the public. Ultimately, what we're trying to do is we're trying to marshal all the evidence and then present that at a trial for 12 trial jurors to decide if somebody is guilty or not guilty. And one of the dangers that prosecutors will often have is overpromising. And you have to remember, we're not the ones in the room interviewing these witnesses. Law enforcement is. And so a detective may come back and tell me, hey, this witness was fantastic. They were great. They give all this information, blah, blah, blah. Well, guess who was not in the room? The defense attorney wasn't in the room. I wasn't in the room, right? All of the additional evidence that's been uncovered isn't in the room. So if you try your case in the press and it turns out when you get to trial that you are wrong, or your witness is not as strong, or this evidence is not as clear as it you articulated, suddenly the defense is going to pounce all over it and make you look foolish and then say, look, this prosecutor has a tendency to overpromise. This is what they've been doing from the filing of this case forward. And they had it out for this guy. They thought they had all this evidence. Turns out it's a house of cards. And the more you build up something and then it collapses, that ends up hurting you. And I'll give you an example of a case that I handled kind of the middle portion of my career. It was not a case that I filed. It was a case that somebody else had filed, and they had gone to our press office and say, hey, we should issue a statement because this seems to have some newsworthy aspects of it. And they laid out what they thought was the case. And then when I ultimately tried it, and the thing about it was a domestic violence incident and involved multiple different individuals who obviously had their own biases and whatnot. But the way it played out in court was radically different than the press release. In fact, after the case was over, the press officer said, hey, we'd like to release a statement. I said, that's probably not a good idea. And she's like, well, we'd like to do one. Let me go through the facts as we had it in our summary and let me know if these things happened. And so she started going through it. I said, that fact is wrong. That fact is wrong. In fact, the complete opposite fact came out. That's incorrect as well. And that's incorrect as well. And so you don't want to overpromise and then not be able to deliver. The other thing that you have is that you want to pick a fair and impartial jury. And the difficulty that you have there is when you have a jury pool where everybody's already made up their mind because there's been so much publicity around a case. Everybody, they walk in like, I think I know everything about this case. I've watched all the news coverage on it, right? They've already made up their mind. And you have no idea as a prosecutor what it is that they have watched, what they haven't, and what do they already think of these witnesses. The same is true for the defense. Now, the defense, all they're looking for is one juror to say not guilty, and then you have a hung jury, right? They're looking to upset the apple cart. I'm trying to make sure the apple cart doesn't fall over. And so sometimes the press coverage, you have to be very, very careful with it, because otherwise what you're going to do is you're going to walk into a room, you're going to pass out a survey and go like, hopefully we have enough people here that we can have a reasonable group of people to pick amongst in order to get a fair trial, because this community is now oversaturated with this information and everybody has their own idea as to it. And the last thing you want is for them to have made up their mind about a case and not be able to really fully evaluate the evidence, either for the defense or for the prosecution. And certainly from the defense standpoint, if they don't feel that they can get a fair trial, that is going to come back at the end. I may secure a conviction, but their first motion is going to be the judge should not have denied our motion to change the venue in this particular case, right? And that's the type of stuff that we as prosecutors have to be very careful of when it comes to trying your case in the press and having those little pitfalls that you can possibly fall into.
Yes. So, of course, we were leading into this other question. What happens if he can't get a fair trial in Moscow? Will they try and get a jury pool from the state of Idaho in general? Well, I guess they would just move it to a neighboring county.
They would. Again, I'm familiar with California. So the typical thing is you would file a motion to change the venue to a different location of where the trial ends up happening. And so you can't leave the state, but you would certainly move the venue to a different county.
And doesn't that then make it a lot more expensive, because then the attorneys, you all have to be housed in a hotel probably?
it's not only more expensive, it really is inconvenient for all of the parties that are involved. I mean, you think about the witnesses, you think about all of the things that you're bringing from one location to another. You're moving people, significant distances to have a trial somewhere else. And it really should be that county. It really should be the citizens of that community that have the opportunity to weigh in. And now it's going somewhere else, and it's inconveniencing witnesses. It's making it more difficult for them. There's a lot of just logistical challenges that happen when you move a case to a different jurisdiction. As prosecutors, we're familiar with, our courthouses and the procedures, and now suddenly you're dealing with a whole different, group of sheriff's deputies, maybe transporting your defendant or ensuring that your witnesses are secure and all the rest of stuff. So it gets much more complicated when you have to move to a different venue. I mean, in some instances it's necessary, but ideally you don't want that to happen.
Mm-hmm. Okay. Yeah. So the same person asked, if he gets convicted, do you think he'll have a good case on appeal arguing that he didn't get a fair trial? Well, we have no idea, because first we have to see, what happens during the trial, right? So it's
right. And obviously what courts do, what a judge's responsibility is to ensure that the defendant, as well as the prosecution, get a fair trial. And so if you do have a situation where, there has been a lot of exposure in the press about a particular case, the judge is going to be very focused on ensuring that they're picking jurors that know very little about the case, or who are very much committed to, I will set aside any thoughts or information that I may have gotten, prior to, because it'd be hard not to see a headline at some point. But, oftentimes you just get that commitment by jurors to say, look, I'm willing to set aside any information I may have and simply focus on the facts and evidence that are presented. And the one thing that I will say is in all my years of doing this, one of the things that I have found is, nobody in the jury pool wants to be there, right? Nobody wants to be there. But once they're sworn, once they're committed to doing the work, what I have found is that jurors take that oath and responsibility very seriously. And they work very, very hard to ensure that they're being fair to both sides. And so, we don't want to put the criminal justice system in a situation where you're making it very, very hard for jurors. But at the same time, the one thing that I will say is the reason why the system works so well is that the jurors that end up sitting and serving are very committed to following their oath. And that allows us to do our jobs.
Mm-hmm. Okay. So this is getting into the specifics of the case, the allegations. Why would he leave the sheath? That seems very sloppy. How accurate is the defense attorney on the pings not being accurate, like GPS for cell phones? Well, I mean, we're dealing with kind of a like, if he is the person that did it, it sounds like people are saying he was a pretty screwed up, very strange individual. So maybe in a way he sort of wanted to play tricks or wanted to get caught, because I've read allegations that said somebody believed to be Kohberger was even interacting online on forums, trying to feed little bits about the murder or what he thought might have happened. There are all these allegations out there.
It's very rare that you find murders that are pulled off without any type of error or mistake. There's always, I shouldn't say always, things happen, right? These are fluid and dynamic situations. You don't know what is going to happen in a particular instance. You don't know if a victim is going to fight or how they're going to fight back. And you don't know when you're operating in the dark if you're going to leave something behind. I've had situations where, this is a silly example, but burglary crews that have repeatedly gone in and done the same type of, pharmacy burglaries, where they're going in, they're using crowbars to break in, they're carrying flashlights, and they're going into these places. And it's, they're quick. They knock out the security, they knock out any cameras, they're in and out of the place. They know exactly what they're going to hit, and they're in and out. Experienced burglary crews, do they screw up? Do they leave flashlights behind when they're fumbling around in the dark and they set a flashlight down and it rolls off the chair and it falls on the ground and they can't find it? Happens. And that flashlight happens to have their DNA on it? Happens. It happens. So you can put any amount of, well, it was deliberate, they did that on purpose, maybe the person was trying to set them up. There's any number of explanations as to why something might happen. And ultimately, is it an important factor or is it not? Is it something the defense can build a case around, or is it something that at the end of the day, the jurors aren't really going to care very much? Like, no, that's a silly argument. So again, until you're actually in a courtroom where both sides are putting together their best case and scrutinizing the evidence, giving the defense an opportunity to cross-examine the witnesses and attack stuff, you don't really know how strong it is or what the explanation may be. So it's hard to characterize, what is or isn't happening. As it relates to online forums and whatnot, as you and I know, in this day and age, it's not very difficult to create an identity and post something. The challenge for law enforcement oftentimes is unraveling that and figuring out who is the person who actually created this account. Who is the person who actually owns the cell phone? Because people can buy burner phones all the time. And you go and subpoena the records and you get it back and it's Mickey Mouse at such and such BS address. And you're like, okay, I have no idea who had this phone. I had no idea who created this account. I have no idea where they're putting out this information. So a lot of it, again, is examining it, a judge acting as a gatekeeper. How is it coming in? What's the foundation, quite frankly, that the prosecutor is relying on to get this information? Because the defense is going to say, no, that's not reliable information. You can't bring that in. And as a prosecutor, I have to explain how I'm going to connect the dots. In the press, you can say whatever you want. Online, you can say whatever you want. In a court of law, I need to lay out the foundation that gets me from this person to this statement. And if I can't connect that, I don't get to bring in that statement.
Mm-hmm.
Right? So, yeah.
Mm-hmm. Okay. Yeah. So
do you want me to comment on the GPS part? Because I can go on for a bit on that.
Sure. Yeah. Because he followed up by saying the defense attorney claimed that the cell phone pings only give a 20-mile radius from the cell tower and would ping since the defendant's house is within 15 miles of the crime site.
So I'm going to have to channel that investigator that works in my office, but he gives an interest. Well, he gives a very basic and then a very complicated analysis of cell towers. And so we have, cell towers are ubiquitous. You have these little towers that exist in all over the country, right? And what they do, what the phone companies do is actually divide it into little quadrants. And what you can identify is based on that, at least some directionality as to where that signal is coming from. So if somebody's driving on the road this way, what you're going to see is this is going to ping off this. And as they progress this way, it'll ping off this. And so you'll see it, same cell tower, but at least it'll give you some directional information. The distance really varies. But what you're doing, if you think about it from a cell provider's perspective, they're trying to saturate an area, right? If you're in an urban area where you have a lot of people using these things, you can't just have one cell tower. Otherwise, the cell service is going to be crap because everybody's going to complain like I can't, because everybody's competing for the same thing. So you have towers that are much closer together. In rural areas, they're much further apart because you don't have as many people. And the amount of distance these things go is pretty substantial. But the other thing you're looking at is geography. So if you have a cell tower in a valley, you may end up picking up a cell tower that is geographically higher up, but is further away than the one that's buried in the valley. A lot of different things come into play when it comes to what is something pinging off of. And so, if I look at cell towers as it relates to Orange County, which is fairly flat and open, versus if I'm in LA going through the valley, right? It's going to look a little different because your towers may end up bouncing off of other things just depending on the topography, also how many towers you have in that particular area. And so as it relates to this, one of the things that's written in here that's in the affidavit is they're pinging off these towers in this one tower pretty consistently. Well, if that's like the one and only tower that's servicing that area, then that's a pretty good idea of like, that's what you're using, right? But if you have a collection of towers, now you're also providing additional information that may or may not help you as you're going through this analysis. So it's, again, the defense from that standpoint, their responsibilities are completely different, right? They can say anything they want in the press all day long and try out different strategies, try and dig out information. Ultimately, when they get to court, they want to have a coherent strategy that they can attack the prosecutor. This may be one way of doing it. But they're also trying to defend their client in the press because at some point he might be a free man. And what does his reputation look like at that point? if you're not pushing back. So what defense does is very, very different than what I do for a living. For the most part, for me, I try to give as little information as possible. I understand, obviously, that our press officer, oftentimes law enforcement's press officer, they need to get some information out to the public. That's their public responsibility. But I'm not trying to try my case in the press. The defense might be, but I'm not trying to do that.
Yeah, that's good to hear you say that multiple times, because, it did seem like for a number of weeks, people were just talking amongst themselves. The internet was going crazy with all sorts of different ideas of who could have done it. And, the father of one of the victims was just going to the media, talking a lot. So, I mean, when you're working for the prosecutor's office, do you sometimes feel frustrated because you can't really speak out to the media and just start speaking back to people that are criticizing your office or saying that law enforcement isn't doing their job or complaining?
It's not only from the standpoint of when you know what you're trying to do, which is to get to the finish line in a trial, right? I'm not trying to get to the finish line in the press. I'm trying to get to the finish line in a trial and get a guilty verdict. That's ultimately what I'm trying to accomplish here. And so it doesn't help me to be distracted by something that's outside of my control, that ultimately does not have, that does not ultimately impact what happens in the courtroom. Now, obviously, if things start going in a direction in the public sphere where it does start negatively impacting my case, then I do have to think about it from that standpoint of what do I need to do to counteract some of that? What do I need to do to address some of those concerns? As it relates to the family, one of the things that's very important as a prosecutor is that we have those communications with either the victim or the victim's family, and have those interactions so that they feel comfortable with what's happening, because you don't want to have them sitting there going, I don't know what's happening, right? Our responsibility is to walk them through the process, is to help and support them through this process, because they've been victimized. They're dealing with their grief, and they're going to have to process their grief. I can't help them with that part, but what I can do is I can explain to them, here's how the process works, right? They should not have any questions as to what the next court appearance is, what is happening as the case is moving along procedurally. When they ask a question like, hey, when's the trial? I might not know the exact answer, but I should be able to tell them, well, here's where we're at. And based on my experience, it takes this much amount of time to get through the preliminary hearing. It takes this much amount of time to get to a trial. Based on the types of evidence we have in this particular case, I expect that this is going to be, it's going to take this amount of time. Based on my experience dealing with this defense attorney, I'm expecting that it'll take this much amount of time, to give them some amount of information so they can understand how the process is going. It's not an easy process for them, but it's something where we can help them and support them, and that's our obligation. I can't stop a dad from going off, or a mom from going off into the press and talking about the case. They have their prerogative to do that. I can't tell them not to do that. I can't tell a judge to tell them not to do that. That's ultimately their prerogative. But I have that responsibility to explain to them, well, this is the reason why I'm not talking in the press. These are ideas as to why you might choose not to either, because it may hurt your son or your daughter's case. So please refrain from doing that. You're obviously free to do whatever you want, but understand that it may have consequences. So, but that's our responsibility. That's we have to have those conversations with folks as kind of the process goes along.
Mm-hmm. And have there been situations where you might have gotten bombarded by phone calls or emails from people in the public that want to give you their ideas or how you should be running things? Does that happen to you much?
Those things don't come directly to me. We route those things back to our press office or to our investigators to handle, because ultimately, we don't want to be in a situation where we're communicating directly with a potential witness. If a witness says, hey, I've got some information, well, I'm not the one sitting down interviewing them. They're going to get handed off to someone in law enforcement, either with the agency or within my own office, to sit down and interview them. If they have an opinion as to how I'm doing their job, they're entitled to that opinion. I will stack up my record and my experience and say, I've been doing this a long time. I've had very, very good results. I do a good job. So if you have a problem with it, you're welcome and entitled to your opinion. If you want to share it on TikTok, go for it.
Mm-hmm. Okay. Thanks, C. Griffin. This person wants to know, do you believe this is a slam dunk case given the vast amount of evidence?
I would never comment on anybody else's case just because I don't have access to any of their records. I have not read the police reports. I have not read the interviews. I have not reviewed any of the surveillance footage. So when they say, hey, we saw the vehicle. Okay, well, what did you see? We saw a white car go by at around this particular time that matches kind of the cell tower, right? Can you tell from looking at that image if it's an Elantra or just some other white, small sedan? Well, it looks more like a white small sedan. Okay, great. Helpful, but not as helpful, right? So there's only so much that I'm aware of just based on what's been made public, and having limited access to everything else. It's hard for me to say if this case is a slam dunk or it's not. There are things that definitely, as I was reading through this, I have questions, because if someone gave me the affidavit, which I did, I reviewed it, I went through it, I took notes, but at the same time, as I'm taking notes, I'm going, well, I wonder about this, I wonder about this, I wonder about this, I wonder about this, right? And if I'm thinking these things, I need the police reports, I need the interviews, I need all of that type of stuff to really evaluate how strong is this case? How good is this one witness in her identification? Because again, she did not see him. She saw someone with the physique that matched him, right? The DNA part of it, I know enough about DNA to say, okay, this is not, what are we looking at? And I've seen enough, well, I don't want to get too deep in the weeds, but you can have something called a mixture, which is multiple DNA profiles that are mixed into something, right? And so that sheath may have that profile that matches him because that's what they were able to extract. But you might also find out that there were other profiles that were on it. They're just what we call minor contributors. And so you can't make out a full-fledged individual or profile from it. Is the defense going to make hay out of it? Absolutely. Absolutely. So, and there's a lot more that you can argue when you have a mixture to say, are we sure that this is the profile? And again, I'm not going to know that unless I have the lab reports that show me the levels and all the rest of the stuff. There's all this other stuff that you can look at. So I would never simply say that a case is a slam dunk or not. And the last piece is we are relying ultimately on human beings to testify. And especially the more and more you rely on a human being to testify as to certain things, all of that stuff comes into play and how believable somebody is. And so, it's hard for me to comment. It looks like they've done a very good job in putting together a case. I don't see anything that's dramatically standing out as a weakness, but there's definitely a lot of questions, even in looking at this, to say, okay, there's some things here that they're going to need to look at. So.
Okay. Yeah. So these are more comments about the case. They were able to determine using FBI forensics. It was a 2014 to 2016 Elantra utilizing multiple video feeds from school and around the home. They were able to confirm the DNA through genealogy records and then confirmed it using the garbage from the home of the father in Pennsylvania. Yeah. I heard about that on the Dateline special also, although it sounds like at first they were looking for an earlier model Elantra. So it wasn't until later they found out that he was actually driving a 2015. But I think originally they thought they were looking for 2011 to 2013. Yeah.
But again, what we're relying on here are descriptors that are being provided in the affidavit or being provided through sources that are providing information to the media. But I would simply say that unless you're actually watching the video, because what it comes down to is me making the claim, hey, this matches, and then I'm putting a video in front of you, and you as a juror looking at it and saying, do you agree or do you disagree? I can have an expert walk in and say, that is a 2013 Elantra, or within this range of 2011, 2016, whatever, right? But what is the quality of the video that I'm presenting? And is there something that stands out about that when that person is now subject to cross-examination? Again, remember, they're writing a report without cross-examination. There's nobody sitting there firing questions and saying, well, what are you relying on? Are you relying on a particular study? Are you relying on an image? What's the image? What aspects of the image are you relying on? Well, what about this other make and model that has this? What if it's been modified? It has this, right? The job of the defense attorney is to attack and to undermine what the strength of the opinion is. So if you're basically saying, hey, you're walking in and nobody's playing defense on you, okay, you can score all of the points you want, but I put a defense on the field and suddenly it changes the dynamics of the game. and that's true for any witness that takes the witness stand. As it relates to DNA evidence isn't, I'm holding up a red pen and I'm matching it to a red pen, and there's only a 1-to-1 match. What you're looking at is you're looking at the individual alleles and you're forming a profile off of it. I know that it's not a clean profile because anytime you're taking something off of a substance, right, you're developing a profile from it. That is very different than me swabbing my mouth and giving you a profile of that, where the only thing on there is my DNA. Mm-hmm. When you have any object that anybody could have touched, and that's the reason why when it comes to collecting what we call a standard from a suspect, you do it in as clean an environment as you can, because you don't want to have contamination. Well, out in the real world, objects are going to have that level of contamination. So I don't know that sheath, for example, has nothing except his profile. In fact, I might expect that there may be something else that's on there because somebody else may have touched it. It's possible that a victim struggled with him and left DNA on that sheath, right? So it's not necessarily a clean profile that's collected from somebody's cheek, taking a cheek swab. That's why we get cheek swabs, is because you want to have that clean sample that specifically identifies what it is. And so what you're doing in this instance is you're comparing something that may have multiple individuals that may be represented on that, some of it which may not necessarily be clean because there may be jumbled up as minor contributors, as I mentioned before, and that's what blurs the DNA when it's in the real world. And that's that challenge. If you have a blood sample, that blood just rings out because it's clearly we're collecting the blood that belongs to a person. You can have a blood mixture. If two people are fighting and their blood mixes in, you might have two people in there. But if it's pretty clear that it's one person's blood, then you're going to get that. But if you're just swabbing off a sheath and it's not some type of bodily fluid, and you're just going off of touch DNA, there's a good chance you're going to end up with either an incomplete profile or a mixture or something like that at least opens the door to being able to attack the DNA. So again, not having seen a single report, I have no idea what's on there, right? But certainly as a prosecutor, I'm looking at it and saying, I've got some questions, show me the report. I want to get an idea of how strong is this evidence on this particular item. Because ultimately, this entire case is based on circumstantial evidence, right? And circumstantial evidence is very, very powerful, but it relies on all of those pieces matching up and being as strong individually as they can. So the DNA evidence, the cell tower evidence, the surveillance video evidence, right? All of those things kind of coming together, and kind of matching up in that way. So.
Thank you. That was very educational. Yeah. Okay. So Paula is saying, why were people worrying that a 6-week investigation was going cold? Yeah, I guess in the grand scheme of things, we always hear about murder cases that have gone cold for over a decade, right? So 6 weeks wasn't that long at all.
No, 6 weeks is not that long because, the thing that people forget, just because you don't see something happening doesn't mean that there isn't activity happening, right? Think of a duck that's on top of a pond. Well, you may see the duck that's on the pond perfectly still, but its little feet are just going. And I can tell you, in working with homicide detectives, they don't sleep. From the moment a crime happens, they're trying to pick up leads and they're trying to basically get as much information as they can. And there are a lot of different ways of getting that information. And unfortunately, some of the stuff takes a little bit of time before you start putting it together. Because think about it from this standpoint. Day one, what do you have? You have a description of an individual who's inside a house based on physical characteristics only. That's it. You have no other information. You don't have a name. You don't have anything, right? From that, you are then hunting and seeing, okay, well, what else do we have? Well, we have surveillance footage that shows a white vehicle driving through the area. But there's no footage that says the white vehicle, and again, I'm working off the affidavit, right? Which typically has the strongest evidence that law enforcement has. This is not that car parking in front of that house. It is not that car parking a block away from that house and a figure moving towards the house. They are looking and seeing a white vehicle and saying, this may lead to something. And mind you, they're getting other leads that are coming in during this time period. Somebody says, hey, I saw this person walking a dog, blah, blah, blah. Now they're hunting and doing that, right? So you've got investigators doing that. And again, I don't know that, but I'm just simply saying that you can imagine this scenario, they're getting other tips, they're following other leads. What you see in terms of this document is it lays out from point A to point B, but you're not seeing all of the random things that they got yanked off of to do before they finally get to this clean path. But you're looking at this vehicle and saying, okay, well, we have this vehicle, where else may it have gone? Because they don't have any cell tower information. They don't have a map as to where this car went. So now they're trying to piece together, where has this gone? And then trying to pull these things together. And then ultimately saying, well, it looks like it may have been coming from this generalized direction. Hey, be on the lookout for a white Elantra of this make and model. Because you're basically saying, I will take anything that looks like a white Elantra. And you happen to have within, week and 2 week time period, somebody who's running it and saying, hey, let's just check Wazoo and see who do we have here that has a white Elantra, right? Mm-hmm. And somebody doing that and then kind of putting those pieces together, going back and looking at traffic stop information, conducting a traffic stop, looking at there's all these things that start happening, but that's where it picks up speed once you're able to start taking this giant universe of stuff and start closing it in. I've had homicide cases where we do what we call a cell tower dump, right? A shooting happens and the chances are that somebody was activating or using a cell phone at that particular time. And what you do is you take the cell tower users for a given period of time, whether it's a 5-minute time period, 10-minute time period, whatever. And you literally have hundreds of cell phones that are pinging off of this thing. And you're saying, okay, here we go, empty the bucket of Legos out. And we're just going to literally start picking out each Lego and we're going to run records checks on every single person, right? You can imagine how tedious that work is and how time consuming that is and how many warrants you have to write to get to your, to AT&T or Verizon or whatever. And they're now giving you records and you're going, okay, let's see if I can match something to something. And you're trying to just put together anything you can. You're going to all the surveillance footage, you're dumping this all out and you're looking and saying, am I seeing a pattern? Is there something that might be helpful here? And from that, you're drawing these lines and saying, well, maybe we might have a lead here. Let's check this out. Mm-hmm. And eventually get to these things. So it's not that it just sat around for a while. Sometimes it takes a while to get a break. And some of these cases, you just have no idea because you don't have enough information, either because your witnesses are dead, they didn't see enough or whatever. And that's how cases go cold. You may get a DNA hit. You may file a profile. Great. But our DNA databases are incredibly limited. The only people that exist in here are people that are in the national registry for crimes they've committed. So if someone's never committed a crime before, or they've gotten a parking ticket for which you don't have to give a DNA sample for, because that never happens, mm-hmm. You're never going to know who that person is. And so it may be years later, the ones you talked, there was a reference to genealogy, right? Somebody thought, hey, if I run it in the genealogy thing, maybe I might be able to get something because someone who is not a criminal, you and I'm interested to see what my genealogical history is, mm-hmm. Right? Now you have a whole wealth of DNA evidence that you can say, well, let me pull it out of there, see if I get lucky in there. But most of the time, law enforcement is just working off their databases. And if someone's never had a contact that would warrant them providing DNA, you're never going to have a hit. And we have millions of people in this country. And I can tell you that we don't have millions of people in a DNA database. It's just not how that works. So even getting a hit like that's great. But it may be 15, 20 years before you find something where somebody does get hit and it pings and the alert comes up and goes, hey, we have a hit on your case, mm-hmm. Right? Yeah. And those things then happen and suddenly, but like I said, there's a lot of different things that can happen, but it's not for a lack of effort by law enforcement. At least with law enforcement that I've dealt with, they work diligently around the clock. And it's amazing when the amount of effort they put into stuff, because they know in those early hours, that 48, first small chunk of time, 96 hours, they have to hit the leads as quickly as they can, because otherwise the trail can go cold. Mm-hmm. And you want to be able to react as quickly as possible. And oftentimes these guys are working on no sleep, right? Wow. They're in a shift. They're working around the clock. They're going home and sleeping for 3-4 hours and they're back at it. Right. Mm-hmm. And in some cities, when you have homicides on homicides on homicides, they're literally going from one homicide to the next, to the next, to the next. The men and women that do this type of work, I have my hat off to them. They work really, really hard. So,
yeah. Yeah, and speaking of the stress and everything, so what's your workload like? I'm assuming that even if you had a very high profile, stressful murder case, you probably still have a bunch of other cases that you have to go to court for, right? Every
Oh,
week.
absolutely. Yeah. So in the part where it's most intense is in these early stages when, you know, your law enforcement agencies are telling you, hey, we now have the driver in custody. We now have the shooter in custody. We now have, you know, the girlfriend in custody. And you're having to decide what their charges are, and you're trying to make sure you have all the information you need to make those charging decisions and what charges are supported by the evidence you have. Now, that may change as you go along. You may add additional charges or take things off, but it's very, very busy in that initial stage as you're kind of going through. And obviously, if you're going to a grand jury or you're doing a preliminary hearing, you know, those are, you know, parts of the process where there's going to be a lot of time, effort, and energy devoted to those time periods. And obviously, as you're getting ready for trial, you've got that going on. But you know, our homicide DAs are not just doing one homicide at a time, right? They have 30, 40 homicides that they're working at the same time. And so you're kind of managing all those cases at very various junctures. I've had colleagues that are in trial when a homicide happens. And so they get out of court, they're throwing, you know, a change of clothes on because they're driving down to the murder scene. And they're meeting with their detectives and they're talking about that case. And then the next day they're back in their trial, continuing with their witnesses and whatever. So, you know, I got to give it a lot of credit to the homicide prosecutors as well that are working, that are juggling these cases and trying to keep this straight and doing the best job that they can in presenting their cases and as well as developing their cases as they're kind of going along and keeping all that straight and not blurring all of that and dealing with the stresses that come with doing that kind of work.
Yeah. And what about like the division of resources? Like, is there someone in charge that gets to decide whether a case gets two attorneys on it or private investigator? Like, how does the work get divided up within?
In most instances, it's, you know, it's a prosecutor working by themselves, and they'll have their normal DA investigator and their team of paralegals and folks working with them, victim advocates working with them on a particular case. We do have attorneys, and again, it varies from office to office how they choose to do this. But we will oftentimes have a prosecutor in the homicide unit that focuses on the law and motion work. And so the trial prosecutor can focus on putting together the case, marshaling the evidence, that type of stuff. And the motions attorney deals with some of those other collateral challenges that happen, which is very, very, you know, specific to the case law that deals with some of those issues. And so in those instances, you'll have two attorneys working together. Where you typically will see a double team or more attorneys assigned to a case, at least in my experience in Orange County, has been on death penalty cases, and the defense will typically have two attorneys that are working on a case on the defense side. Doesn't mean that we're going to stack it with another attorney, but it's not uncommon to see two attorneys working on a death penalty case on the defense side. But it really kind of varies. Oftentimes it's dictated by the charges and what you may be putting on or what you may be combating against as a defense attorney. But ultimately for us, it's one prosecutor in the room that's making these decisions. You will oftentimes rely on your colleagues for advice, for suggestions, trial strategy, that type of stuff. You may talk to your supervisor about some of those things as well, but it's pretty much just us in the room.
Okay. Yeah. Let's address a few more things. And I know it's been over an hour already. So thank you guys for having so many good questions. Let's see. Yeah. So ultra testosterone says he thinks outside of the DNA evidence, the case isn't that strong. I mentioned that one of the surviving roommates did identify, or at least said that she saw him and that she noticed it was a tall guy that looked about 5'10" and had bushy eyebrows. But yeah, so I have no idea if she might have been shown a bunch of pictures and picked him out also. I mean, there's a lot of stuff that was redacted. And of course, the arrest affidavit doesn't even have to have every single thing in it. So yeah, so it's kind of hard to say at this point, you know, is it a slam dunk case or is it a, you know, like a not strong case? I have no idea.
Yeah, and again, relying simply on the affidavit, when you're talking about circumstantial evidence, in other words, you don't have direct evidence. You don't have somebody that says that's the person that did it, right? But you're putting together the physical characteristics plus the cell tower, plus the car, plus the DNA to put all these things together. The DNA in and of itself is helpful, but it doesn't really provide the entire story. The cell phone data doesn't provide it either, because there's this gap of time, again, relying on the affidavit, where the phone goes dark. Its direction of travel towards Idaho and direction of travel going back home, but in the time period where it's near the residence, none of that data is there. And again, I don't have access to the thing, so I don't know if it's just dark, completely empty during that time period, which would, in reading the affidavit, that's my interpretation, is that he shut off his phone or whatever. So you don't have the car going all the way to the residence, but direction of travel coupled with surveillance video, coupled with the DNA, explain like, well, it's kind of coincidental that this particular item is here that connects to him. So you add up all those pieces together, and that's kind of where you go. And that's not uncommon in a homicide case, right? You're ultimately putting these pieces together, and it's the defense's responsibility to attack each one of those pieces. And at the end of the day, stand up and say, hey, if this has problems, and this has problems, and this has problems, and this has problems, do you think the prosecutors really proved this case beyond a reasonable doubt? And where we're saying, what's the one thing that can explain away all of this stuff? Because there's a consistent theme here. We don't have a person that says that's him, but all the rest of this physical evidence, which you cannot manipulate, is saying it's him that committed this crime.
I see. Yeah. So I don't know if you can answer this or not, but what about the data they will get from social media and other devices? Like, let's say, I know people are out there on the internet saying that, oh, Bryan posted this thing back in 2011 where he was talking about his feelings about his family and being depressed or whatever, or, oh, then he posted this thing on Reddit, or, I mean,
Sure.
How much of that stuff do you think would even be admissible in court, even if they could tie it to Bryan?
I haven't looked at any of that information, so I can't say definitively on any particular item. But what I would say is it's the judge's responsibility as a gatekeeper, and to some extent as a prosecutor, you're self-editing as well, because you're not going to walk into a court and say, hey, there's this random post that he made a decade ago that I'd like to introduce for intent to kill 4 people. Okay, well, he's commenting on something else, or he's commenting on his family. Like, what is the connection to this? Our criminal justice system is set up in a way where we don't tar and feather somebody based on the sins of the past. We do that in the public, right? But in a court of law, there are rules about what's coming in and what's not. Is it more probative than prejudicial is the basic test. And if the prejudicial effect is such that it outweighs any probative value. So something like that may have such low probative value, but the prejudicial impact, even if it's slightly higher, that's getting it out of there. It's not coming in. And so you really have to look at what's the connection to this particular crime, right? And how is it being brought in? How is it relevant to the analysis? In the rules of evidence, the prosecutor, we're very much limited on the types of evidence we can bring in. It has to be specific to this crime. If it relates to prior conduct, as it relates to prior intent, as it relates to all these other things, the way the case law is set up is it ensures that those things are very relevant and very probative and are closely connected to the crimes that are at issue. And unless it has that connection, a judge is not going to let it come in. And it also goes back to those foundational things of, how do I know that he's the one who said this? If this is a post, how do I know that that is his user identity and that somebody else didn't post it on his behalf, or somebody didn't create an account and post this? Because there's all these different ways of spoofing this stuff, right? And so it really is behooves me to get that. If I want to use it, I need to connect the dots. If I want to use it, I need to convince the judge why this is relevant to this particular case and how it still has bearing 10 years, 50 years, or 10 years, 5 years, 1 year in the past, like how that ties in. So, that's where some of that stuff that we can't really control comes in. Is it ultimately is also a judge's discretion as to whether or not something should come in. They're the gatekeepers of the evidence.
Yes, definitely. So there will definitely be a lot of evidentiary motions before any sort of trial. So,
but even as a prosecutor, I will tell you that you want to put your best foot forward. You don't want to be putting in evidence that is a stretch, is a reach, or is very, very weak, because the last thing you want is the Court of Appeal saying, hey, yeah, Mr. Prosecutor, you got a conviction, but this piece of evidence should have never come in. I don't even know why you tried to get this in. This is really pushing the envelope. It's very prejudicial, and therefore you're going to have to redo this again. So now after a conviction, 3 years, 5 years later, boom, you're starting all over again. So, that's kind of the situation that you're looking at. Is you want to be careful with what you're actually choosing to introduce. I think in terms of what they've talked about and delineated in this affidavit, as I've kind of explained, these are all powerful pieces of evidence. It is circumstantial evidence, but circumstantial cases are based on taking one thing and another thing and putting it all together and making a puzzle out of it, because you don't have a situation where you have direct evidence. Because if we were always relying on direct evidence, that was the only thing, there would be tons of cases that would simply be not prosecuted because your eyewitnesses are dead or don't exist, right?
That's right. Okay. I don't think you said you knew much about the Dan Markel, the law professor murder case. Have you heard about this? It's in Florida. Has to do with.
No, I have not paid much attention to that.
Okay. Yeah, because a lot of the things you've touched on are issues that people have been talking about in regards to the Dan Markel law professor murder case in Tallahassee. So Charlie Adelson is his former brother-in-law who's going to be on trial next spring for being part of the murder conspiracy. It stemmed from a bad divorce and child custody case between the law professor and his ex-wife. So I've been covering that a lot on my YouTube channel, but I know you're too busy to watch it all. But so a lot of the people out there watching right now are also big fans of the Dan Markel case, and we're all glued to all the details. But similarly, there are allegations out there that Charlie Adelson had sold steroids and marijuana, that he had, gone on sex tours to other countries and, done all sorts of shady things. But I don't think those things would be admissible in his murder trial.
Not unless it was relevant to establish motive. So for example, if one of those businesses or things that they were doing was connected to the conspiracy, was a motivation behind the conspiracy to commit the murder, I think that might come in. But oftentimes when we're thinking about dirtying up somebody, right, when you're sitting there and you're saying this person's bad because they did X, Y, and Z, that stuff's not coming in a trial unless that person testifies. So if a defendant chooses to take the witness stand, then immediately their credibility is put into question. And that's true with any witness that takes the witness stand. And so you can cross-examine on the facts and circumstances on the case, but you can also, to the extent the court allows you, to attack their credibility in other ways. Well, you were convicted in the past of defrauding grandmothers. Isn't that correct? Right? You were convicted or charged with selling drugs. And what you're looking at are crimes of moral turpitude. You and I understand what that means as lawyers, because it prevents us from getting a bar card, right? And there's certain other professions where, crimes of moral turpitude are, count against you. But the whole point of it is, what is the nature of that other conduct that casts a light on somebody's credibility? And how do you prove that? If it's a conviction, a court's going to let you use that, assuming it's not decades in the past. But if it's some allegation that, let's say, the neighbor down the street says, well, I saw him steal this person's lawn chair, is the judge going to allow a separate small trial on whether or not this guy stole a lawn chair to affect his credibility during the course of a trial? That's what a judge is going to decide. I don't really want that. I don't want a side trial on it, so I'm not going to let you in it. Ask, Mr. Prosecutor. You don't get to ask isn't it true that you stole the lawn chair? I mean, if he says yes, then there's no small trial. But if he says no, I now have to bring in the neighbor who's going to come in and say, well, I saw him steal this lawn chair. And then he's going to cross-examine and say, oh, yeah, well, the reason why you say that is because you and I have been fighting about our Christmas ornaments for 12 years. And now some of them go like, I have no idea what's happening here. I've lost complete control over this, right? So you have to look at what it is that's being used to attack the credibility, and a judge is going to make that decision of, is this coming in or is it not? And like I said before, as a prosecutor, I need to figure out, do I want to use this or do I not? What's the most effective way of me challenging this person's credibility? But in a lot of homicide cases, quite frankly, the defendant's not taking the testify. It doesn't necessarily help them. And oftentimes their attorneys will tell them, don't do it. We don't want you to be up there getting attacked by the prosecutor. In some instances, you have to, because you're putting on a self-defense. And the only way you're going to get the self-defense story is if you testify, right? But a lot of other instances, you let the defense attorney do their job. And in a case like this, is he saying self-defense?
No. No, there's no self-defense here.
This is probably a case that sets up for, I wasn't even there.
Yeah,
right?
he wasn't there. He hired, or he allegedly used his ex-girlfriend as a go-between to hire a couple of hitmen to go and shoot the law professor.
There's a lot of different ways of just, again, it comes down to the evidence that you have. How do you go about putting on the case? What is the logical thing? Does it make sense for a defendant to testify? And if the defendant doesn't testify, all of this other stuff's not coming in, right? Those are the basic rules as it relates to evidence of that stuff's not coming in.
Yes, thank you for that bit of knowledge in a nutshell. This is a very educational interview. Do you have time for a couple more questions?
Yeah, I'm fine. Yeah.
Okay, sorry about this.
And if at some point you want to invite me back to talk about the other case, I can look into it and get back to you.
Okay, sure. I think a lot of the big time followers of this channel and the Markel case would love to hear your views on it once you've read, or assuming you have time to read more about that too. Okay, why does the oath for the witness include "so help me God"? What if you don't believe in God, and how does separation of state or church fit into this?
We, at least in California, and again, every jurisdiction is a little different. We don't use a Bible, for example. When someone comes in, they don't put their hand on the Bible and raise their right hand. They just raise their right hand and they swear to basically tell the truth. That's basically what it is. And so it's an oath. But as we all know, in a court of law, people lie all the time. So what it does do, it subjects them to perjury prosecution. But for the most part, people do take their oath seriously and they do their best to tell the truth. But are there people that come in and lie? Yes. And whether it's on a Bible or not, I don't think that makes much of a difference.
Yeah, I think here in North Carolina, they even tell the person, do you want to swear or affirm?
Right.
And a lot of times people are like, oh, I affirm, whatever, like they don't make a big deal about making you take out a Bible. So let's see. Okay, yeah, sorry about this, but we probably have to wind this down real soon. Yeah, I'm not sure what this question is. How would the defense ask for close witnesses' testimony? Yeah, I'm not sure, but the defense is entitled to already, get the names of all the witnesses and the statements, and they have the ability to take depositions, right?
There's really not any depositions that happen in a criminal setting. So what they would ask for is, not even ask for, they're entitled to all the evidence that we're going to use, as well as any exculpatory evidence as part of our Brady obligation to turn that over to the defense. So they have access to that. There are instances where you can go to court and you can ask for a delay in the production of certain items, depending on if there's a threat, for example, to your witnesses, threat of injury, that type of stuff. Not uncommon in gang cases where you have individuals that have been harassed, threatened, and where you're asking for the judge ultimately to, hey, you can delay your statutory requirements in terms of turning over evidence, or these are the conditions in which you can turn it over to the defense. You can redact certain information or whatever, or you can make this a witness available during this particular time period or in this particular way, so the defense has an opportunity to meet and talk to the witnesses. So the defense can do all the investigation they want. Whether or not people choose to talk to them is entirely up to them. They're under no obligation to talk to anybody. Unlike a civil case where you can depose individuals, that doesn't happen in a criminal context. We use the subpoena power to bring witnesses to court in a trial. We'll oftentimes have them testify at a preliminary hearing. So the defense does have opportunities to cross-examine some of these witnesses at an earlier stage. And so some of those things are there, but there isn't a way that the defense can ask for a closed testimony. I'm trying to understand what the question is. It is public testimony, and that's just kind of how that is. But if they want to go interview a witness, and the witness wants to talk to them, they can do it in whatever setting they want. They can take them down to the office. They could have it at the local park. It's really up to them.
Okay. Quick question. Do you have any comments about the Andrew Tate situation?
I don't. Yeah, that's a whole different situation, especially when you're talking about extradition and a bunch of other things. That gets much more complicated.
Okay. Is not calling 911 when people are in desperate need of violation of civil rights of the victims? Well, but that's not usually a crime, right? Because in general, people have no duty to.
Right. No one has an affirmative duty to anybody else. So no, your failure or neglect to call 911 is not going to get you criminally charged. I don't see that happening or changing in any jurisdiction.
Yeah. I mean, it's frustrating though when you see some egregious cases where, like I remember hearing a couple of years ago of, was it firefighters or police officers who were just laughing as a man drowned in front of him, in front of them, and just kind of making fun of him. But, there was no duty for them to jump into the water and rescue the guy. Yeah, really, really sad. So thank you so much. Are there any parting words that you would like to let people know about, what prosecutors do, or any misconceptions that you want to correct out there?
No, I think I've covered a lot, and I appreciate the opportunity to talk. And obviously, it's great to see you. Anytime we are able to see each other and hang out, it's great to catch up, and kind of share, because you and I have gone completely different paths, from
Totally.
from college and even from law school. So it's great to spend some time with you.
Okay. Well, Cyril went to Hastings, which is now known as, what is it again? UC.
So it's University of
San
California
Francisco?
College of the Law, San Francisco. So, a lot of these institutions have been changing their names because of issues in the history of the founder or the names that are attached. And so, Bolt Law School, for example, changed their name to
Berkeley.
Berkeley Law or something
Law.
like that because of the connections to Bolt. Hastings, same type of thing. So recently that happened and the legislature signed off on it. So that's the new name. It's still a mouthful that I'm still trying to figure out. But that's kind of the new name for my law school, even though I'm still an alumni of UC Hastings. So.
Yeah. Well, I'm just really impressed that you have made this into a big career, because a long time ago when I was in law school, I interviewed with some PD's offices and district attorney's offices, but ended up just working in the private sector. So it seems like you have to have a real go get 'em type of personality and really
not necessarily. I would
on stress to do
to
this.
that. I would say no, that's not necessarily true. I would say in terms of myself, I did not know that I was going to go into the line of work for the amount of time. I when I was coming up, I wanted to be a trial lawyer, but I didn't necessarily know that I was going to be a prosecutor. But I appreciate the opportunities that were given to me, and I appreciate the fact of what the prosecutor's office allows me to do, because you're an advocate, but at the same time, my responsibility is to do justice. And so it is not advocating on behalf of victims. It's advocating on behalf of justice, because victims come in all shapes and sizes, right? Mm-hmm. And we're ultimately trying to do the best for society. And that's what I think sometimes people forget. We have these conversations about progressive politics and progressive prosecutors, or these, staunchly, law and order type. Ultimately, our oath as prosecutors is we're supposed to do justice. That is in U.S. Supreme Court cases. And how that gets interpreted may vary from prosecutor's office to prosecutor's office, but that's what we're charged with. And so that's a great way of looking at the job. And it allows you to really keep that in balance, because we're not supposed to be win at all costs. We're supposed to play fair. And the expectation is we're going to play fair and represent the system fairly, regardless of what happens. So the defense attorney can play all their games and do tricks and all kinds of just crazy stuff to get us off our game or to do things that are unethical. But ultimately, I'm not allowed to stoop to their level. I have to maintain ethical integrity at all costs when I'm prosecuting cases. And that's what prosecutors have to do. So it's very different from the civil world in that respect. And so much of what we do really depends on the camaraderie that we develop with defense attorneys on the bench and whatever, because, how we conduct ourselves, that's how the legal community views us. And if we're doing shady stuff, we've destroyed our reputation. And you might as well just stop being a prosecutor at that point, because you're going to lose credibility with the bench. You're going to lose credibility with the defense bar. You can't do your job effectively as a prosecutor and represent the people of the state of California or any jurisdiction. So no, I do love the work that I do.
Yeah. Okay, great. Well, thank you so much. So we'll go ahead and end the live stream. You can stay on for another minute so I can say goodbye to you personally. Ultra Testosterone is very pleased with your appearance here, and he thinks you're a very sharp and ethical person. Do former prosecutors often become unethical when they switch to being defense attorneys and white-collar investigators? I don't know. He's not going to say anything negative.
I'm not going to answer that one.
Other attorneys like that. Right. Yeah. But thank you guys out there who also supported with those super chats or super stickers. Appreciate everybody for tuning in. And thank you so much for your time, Cyril.
Absolutely.
Hope you'll come back in a little bit. And, there are just,
Anytime.
unfortunately, so many wacky or very strange, convoluted criminal cases out there that people are really interested in. So hopefully you'll be able to come back and discuss some of them in the future. So thank you. Okay,
Sure.
thanks everybody. See you guys next week.